Thank you. That's very helpful.
Sure.
So I see in the chat that Yannick says she has a mix of contractors and one employee in the USA.
And great. That makes it extra confusing for poor Yannick. But it sounds like you've given some deliberate thought about who should be a contractor and who should be an employee. That's good. So for employees, the Department of Labor's got the gold standard Cadillac of laws that started in 1964 as part of President Johnson's Civil Rights Act. It's called Title VII of the Civil Rights Act, the Equal Employment Opportunity. And we call them the EEOC, the Equal Employment Opportunity Commission governs this giant employment law that has grown and grown since 1964 to cover all types of discrimination. And discrimination is when you treat somebody differently because of a protected characteristic, something that they cannot change about them. Unlike I could change my hair color if I wanted. I could change my weight if I gave some effort. But these protected characteristics are things that are inherent to a person, cannot be changed, and therefore we have to tread very carefully to make sure there's no even perception that we're treating somebody differently because of their national origin, their race, their color, their religion, their disability, their genetic information. That just happened in the last 10 years that got added to this list. And then the two biggies are treating somebody differently because of their age. And old age is 40 and older, not white haired and looking stooped. It's 40 or older. So for many of us, we're in that protected category. And their sex, and sex doesn't just mean gender, like we're a female, you can't treat us differently because we're a female, though it does mean that. It's been iterated over and over again, so that sex includes now pregnancy or lack of pregnancy. It includes how you identify as a gender and your sexual orientation. Those things just happened in the last year or two. So you can see how this law evolves, and there's always something new to watch out for. I love showing this slide because, let's face it, nobody discriminates purposely, right? Not one of us founded our business and has that bad maliciousness in ourselves. But it's very easy for small businesses to inadvertently get a claim of discrimination against them. And it costs a lot of money when that happens. You can see, I purposely choose for my website to showcase small businesses, fewer than 50 employees for the most part, that get a claim of discrimination. And it turns out that they maybe did do something wrong accidentally to run afoul of the Title VII of the Civil Rights Act, and they have to settle their claim for $80,000, $90,000, $150,000 because they don't like their chances of taking it to court. And that scares me to death, to think that perfectly good people who have just because they didn't know about employment laws wind up having to pay huge settlements to settle a claim of discrimination. The one big one in there, if you saw it, the $1.8 million, that was the one that was intentional discrimination, nasty, disgusting, willful, and I'm sorry, it wound up being, $18 million just to settle that claim. We'll never be there, but it would be easy to draw a claim of tens of thousands of dollars. So how do you protect yourself against it? Here's what I recommend for recruitment, because here's a weird thing you might have noticed in what I just showed. You're responsible for not just your employees, but your applicants too. And you would think, like, applicants, why do I have to be responsible for them? I didn't ask them to apply. I don't know anything about them. But applicants get their heart set on your jobs, especially for those of you, and I think it was everybody who I heard, who has kind of a glamour about the company that they've got. It's international, it's woman owned, it's for a cause, whatever reason, you are winning hearts of applicants who want to work for you. And they may be passionately attached to what it is that your company does. Or maybe they're just desperate for a job, but either way, they get applicants get emotional. And when they get rejected, we tend to think, well, it's not me, it's you. You rejected me because I have this protected characteristic that you don't want any part of. And that's not true, but it's free to make that claim. The EEOC will listen to all people who care to allege some discrimination happened. And it's on you now to prove that you made your recruiting choices and hiring choices based only on business related reasons. So I suggest open your searches to the widest, most diverse audiences you can find. Put your job ads on state unemployment boards, diversity websites, veterans websites, anybody who's out there serving underrepresented populations, throw your job ads and try to recruit from there. Easy to do, have an equal opportunity employer statement on every job ad in your application that just goes on record to say that you are considering everybody who wants to apply regardless of their protected characteristics. And then something new that's just happened in the last couple of years, many localities and states have criminalized application forms that ask people if they've ever had a criminal arrest or conviction, or even what their previous salaries are, because that is seen to deter people who maybe have been arrested unfairly or convicted unfairly, and shuts them out of your hiring process instead of welcomes them into your hiring process. So those are all things that you can do to make sure that your recruiting is compliant with the Title VII EEOC laws. No matter what, make a note every time you reject an applicant, make a note right then and there why you rejected them, so that, gosh forbid, you ever have to prove your rejection decision was work related. You have something that says he didn't have enough experience, or she is overqualified, or she is underqualified. Whatever it is, keep a note of it and keep your applications on file for a couple of years so that you can defend against claims. Same thing goes with when you interview people. You want to keep your small talk limited to topics that are not going to reveal a protected characteristic inadvertently. And I've worked for plenty of people who start off interviews or warm up interview candidates with, so tell me about your family. Do you have kids? I have kids. Do you have kids? You can't do it. The best way to do it is keep your small talk limited to topics that'll never go somewhere personal, and ask every candidate the same job related questions. We call it a structured interview. It's much more comfortable to just sort of have a conversation with a candidate, right? It's casual, it's informative, but that's where you get into trouble. So draw up a list of job related questions, and you can even apologize to the candidate and say, I ask everybody these same questions, so it's going to sound a little robotic, but I'm going to take notes. And then rate each answer, add up scores. If they if they answered a question, great, it's a 10. If they didn't answer the question, it's a 1. And then make your hiring decision based on those score sheets, along with other quantifiable data like previous projects they've worked on, for example. The worst thing that could happen is an applicant who interviewed with you. And if you think recruiting candidates feel bad getting rejected, somebody who interviewed with you and then got rejected feels 10 times worse. the worst thing you could do is say, I just clicked with this person better. We had chemistry, he fit in. That's the worst thing you could say. So only keep records of your quantifiable data and your score sheets for the interview. Any questions so far? Florence, I like that. I knew Florence would be big into structured interviews. That's the way to do it, right?
Yes. So I'm actually working. Yeah, I'm working with a client right now, and I'm helping them design every single interview based on competencies, based on the values of the organization that we agree on in advance, and even agree in advance of the elements of the response that would constitute a 1, which is low, versus a 5, which is high. Because even myself, I can testify, I recently was doing a screening, and even with all of this, it is so hard to stick to the elements of the response and to try to limit the bias. I mean, you do have to connect ultimately. So the person has to gel with your team, but there are rational ways where you can explain and review that. And one of my questions is, what if some of the members, like, for example, for me, I'm working with a client, but what if the hiring manager is not actually taking notes? What do you do? What's your recourse?
It's bad practice to not take notes, not just for compliance reasons, and to be able to provide evidence that you were listening for answers and doing your due diligence and finding the right person's qualifications, but also because I think candidates appreciate it when you take notes, because I know I've been in interviews where a hiring manager didn't take notes, and I've walked out and thought, you're not going to remember a word I said. So, like, how interested in me were you really if you didn't write anything down? So it's always a great practice to take notes. If you get distracted, and it happens to me sometimes, I get so engrossed or excited with what somebody's saying that I forget to write. But as soon as they're gone, quick, write down your notes before it leaves you, so that you keep their resume and your reasoning and their answers right next to each other. And Florence, thank God for you for drawing up those structured interview questions, because it takes an expert to be able to come up with questions that will actually provide responses and answers that are meaningful and helpful to the ultimate hiring decision. It's too easy to just pull something up on the internet and say, tell me about yourself and where do you see yourself in 5 years? So I'm glad people have you to really help them suss out the best candidates for their organization while being compliant with the recruiting and interviewing rules. Anything else about recruiting or interviewing?
So I had two things. Really, Danielle, more is just kind of philosophical things that I think about rather than necessarily, you'll hear what I say in a second. So two things I think about is, one, I know some companies sometimes try to even take names off resumes as they are circulating them to, say, a panel that might be reviewing resumes, again, to the point about implicit bias. So I think about that. And the other thing I think about is, as we're hiring, is, some people are just really good interviewers, and some people are not. And so thinking about that aspect, as well as just going through interviews, like ways of actually assessing how good someone is in an interview, in an actual job, particularly thinking about technical jobs or jobs that require specific, all jobs require specific skills, but I think you understand what I'm saying.
Technical knowledge of something.
And whether it's sometimes, someone has to do some sort of project or exercise, et cetera, and yet not wanting to be onerous on a lot of candidates.
Applicants' time.
Obviously you do that towards the end, but anyway, I just wanted to raise those two things, not to get us off topic, because I don't know if you're running behind schedule, but I just wanted to share those two things.
Thank you for the feedback. And it's so ironic. The best interviewers are the ones that had the most experience interviewing, right? And so when you see them, you have to be a little suspicious of, oh, you knew where I was going with this. You must do this an awful lot, which is not a good thing, but it's easy to be charmed. Really good points, Christina. And if we have time, I'd love to address the not wanting to be onerous to applicants, because there is something to that for sure. Okay, so you've hired the employee, right? This is my favorite trick for small businesses that takes care of so much HR compliance with such little effort. And that is to set up a proper HR foundation to protect your company. And an HR foundation to me is those documents that you need that are going to say the right things, going to have all the keywords that will not just comply with all of the local, state, and federal employment laws, but they're also going to protect your company and give your company flexibility so that you're in control of the employer-employee relationship and the way you know you want to be to run your business. So an HR foundation, you do it once, maybe you look at it every year or two to update it, but once you do it, hopefully it's done. It sits in a drawer, it collects dust, and you never need to revisit it again. But if the EEOC or any government entity comes calling, or an employee or ex-employee's got an attorney who makes a phone call, these are the first things you're going to need to show. It includes a job offer letter, and your job offer letter is going to have language that says, among other things, that the employee is employed at will, and either of you can terminate your relationship at any time without notice for any reason, which means you don't have to wait till somebody does something horrible before you can fire them. Your employee handbooks and the policies in them not only give you the ability to create the culture and the rules and the structure that you want in your business, but it's going to automatically comply with all of the employment laws, as long as you follow what's in your own employee handbook, because it'll just address and go on record to say, we comply with every single thing you've asked of us. My favorite trick is to have an employee sign an arbitration or mediation agreement when they get hired. And they are not allowed in California and in some other places right now. Eventually, probably every state might outlaw it, but right now in our area, they're good. And an arbitration agreement is something an employee signs on his or her first day that says, if I ever feel like suing you, if I feel like you've done me wrong, I agree to have my case heard by one single impartial arbitrator behind closed doors. And that one person will make a ruling on a reasonable amount of money that I should be paid if he finds that I have been discriminated against. That automatically takes those high jury awards off of the table. An employment attorney, an employee's attorney doesn't get the chance to showboat in front of a jury and pull at their heartstrings and win their sympathy. So it's a really easy way to counter a possible claim against you for discrimination. Same thing, you're protecting your company if you have a non-compete, non-disclosure agreement. And finally, in your HR foundation, you'll want to have a job description that not just points out what's required to do the functions of the job, but also what the physical and mental requirements are too for doing that job, so that should an employee ever become disabled and not able to do the job, you've already gone on record with saying, but you agreed that the job requires this. So those are all things, again, that you can do pretty quickly, and you only have to really do it once. And last but not least, once you have an employee, of course, now they're really vested in you, right? You are their everything. You're the reason that they can feed their families. They talk about you all the time with their friends. Their egos rise and fall based on your compliments or critiques. So should you wind up having to terminate one, their feelings are really hurt and they're really saying, it wasn't me, it was because of my protected characteristic. They'll never come to you and say, I believe I am being discriminated against. But the EEOC says, you know what? If you have, even if the employee doesn't say that, if they don't use the magic words, it's still incumbent upon you, the employer. If you could reasonably be aware that that was happening, then you have to take responsibility for that treatment. So employees may come to you and say, I'm not being treated fairly, I'm not being treated well. Just because they didn't use the discrimination word, you still got to stop and ask them, like, tell me what that means. What's the treatment? Why is the treatment? Who's treating me this way? What did they do? When did it happen? And then even better, after they tell you about it, have them write a statement, because more often than not, what happens is they go to the EEOC if they've been let go, and they say, I told my boss, but she didn't do anything about it. And that's a big deal if you ignored it. So you'll want to be able to say, look, I took notes. The employee told me they were being treated unfairly. I took notes. They said this. There was no mention of disability or groping or whatever their big ugly allegation is now. And you've got proof that this is a brand new thing that the employee just made up after they were terminated. The same way they don't have to use the exact words of discrimination. You are also responsible if you hear rumors that from people that there's been discrimination. You're responsible if you see like maybe a disability, or an employee calling out sick a lot, but you don't recognize that as, oh gosh, this person might be disabled, and now I have to make sure I'm not treating them differently because of their real or perceived disability. Inequitable wages, you guys see on the news all the time, people are looking at females being paid less than men for doing the same job. So it's a good idea to always audit your pay records to make sure that things are equitable based on all those characteristics, protected characteristics. And then finally, I want to give you, if I can, I'll put it in the chat if I can, the gift that the EEOC gave us HR people around Christmas. They actually wrote out a chart of the biggest risk factors for harassment and discrimination as they see them, what they are, how you would identify them, and what you can do to ameliorate them, I guess. So let me see if I can put this in the chat. Or Florence, are you able to do that more easily than I am? If you have access to what I sent you over yesterday?
Yes, and I can, we'll send a follow-up email to everyone. Great. And we can add that in the resources.
Okay, great. Let me go back to my PowerPoint and stop sharing my screen, but I want to thank you all very much for attending and for your contributions too. And I'd love to take your questions about anything that you've got.
Thank you very much, Danielle.
Thank you.
I saw a question early on from Lara about H-1B visas.
Mm-hmm. What's the specific question? I can tell you in general, in case this is your question, that H-1B visas are when you the employer are guaranteeing to the US government that you have done an exhaustive search within the United States and you cannot find anybody who has the exact specified knowledge and qualifications that this job needs. For example, if you need somebody who speaks Swahili, has a PhD from a certain region in Africa in this certain box or body of knowledge, you can't find one in America. You could try, but you won't find one. And H-1B visas are fantastic for that point. But your run-of-the-mill positions, the government wants you to fill them with U.S. residents who are legally qualified to work in the U.S. first before you go and seek out approval on an H-1B visa. And it's tough. We tried. The last company I worked for was a hospitality company. We could not get enough summer staff to clean our hotels and resorts. And boy, was it tempting to just ask for H-1B visas to bring over people, but we can't. There are people in America who can clean rooms. We just weren't paying enough for them.
So is it kind of not worth trying? There is a lottery. I was told there's this lottery in March and you can enter it. And if you can come up with an argument,
yes,
is it worth giving it a shot?
I think it's worth giving it a shot. If you think you have a solid argument and the argument isn't, but I can't afford an American for this highly specialized job, then yeah, go for it.
Hey, my name is Jack. I'm a technical recruiter. I've been doing this for a while and just started my own business. But
hi, Jack.
just to add some insight into that. So with the H-1B lottery, it does get pretty tricky. So some things you have to keep in mind, and Danielle probably knows this better than I do, but country of origin, and also like how much time they have outside of school, if they're on some kind of OPT visa. There are a lot of different factors, but the underlying thing that I always express to my clients and to the company that I work for at the time is that most of the time, if somebody's coming from one of the BRIC countries, including India or China, you're most likely not going to get selected on the first round of your H-1B lottery. So it is a gamble in that way. It sometimes is easier to set up your business entity in places like Canada or something like that, hire from there and go through their lottery system in terms of visas. In the US, if they're coming from a country with a severe backlog of people waiting in line who already have like their, I'll spare you guys the jargon, but I-140 approved, it does take a while. And usually, depending on the time of the year that you file for this lottery, it will most likely take another year. So the way that they do it is you kind of get in process the first year, and then if you don't get selected on the first year, then you're more likely to get selected on the second year. But there's a million different factors, including the type of job and all of that. It's just usually the bigger companies get the first picks, so to speak.
Wow. Thank you, Jack. I didn't know that. That was good for me to know too. Thank you.
Thanks so much. Yeah.
Anyone else have questions?
I have a question, but I realize I spoke already. So if somebody else wants to speak, I can hold off. Okay, so
go for it.
So my question, I really appreciated your designation at the beginning of making us think about contractors versus employees. And I also appreciated you talking about how there can be, I think it's your word that you use, creative ways to set up employee relationships so that you are compliant with the Department of Labor. So my question is this though. So, I would be hiring in a right to work state. Or I'm sorry, I think, no, I'm sorry. As you just said, employees are employees at will in my state, right?
Great.
So at some level, right, like we could I'm just using like fire this person at any moment.
Mhm.
And yet I kind of don't want to, if I'm going to hire them, I don't want to set that up to have to fire them. And
Right.
in that, would you, and yet I don't know about the ideas about setting up contracts,
Right.
right? So I guess my question to you is, given the many states around the United States are employment at will states, and if
Mhm.
we want to set up temporary employment situations, what is your recommendation, realizing you're not a lawyer,
Mhm.
as to how one would best do that?
So such great questions. And you're right, because this HR foundation I talked about, especially, you don't want to start off on an ugly tone of, let me tell you that you can be fired. So you want to let them know that you're an employee at will, and that mutually gives us rights. After that, however you want to set up a relationship with an employee is limited only by your ability to recruit and retain them. So, for example, if you wanted to if you wanted somebody, but you just really needed them 8 hours a week on Fridays because it's end of the week and you like to get things done, you can set up an offer letter. I don't like employment contracts at all. An offer letter will have all the terms that you'll want to put in a nice, friendly, positive, welcoming way. And your offer letter will say, this job is every Friday from 9 a.m. to 5 p.m. Now, the worst that could happen is you can't find somebody who wants to work those hours. But in this economy, there's so many flexible applicants right now. I haven't seen anybody have a problem with any kind of part-time thing they want to do. So good point. Do an offer letter, not a contract, because you can create the positive tone. But that's one of the terms in your offer letter is when they will be your employee.
As well as the potential temporary nature of the employment.
Yep,
okay,
exactly.
great. Okay, thank you. Super helpful. Appreciate it.
Great questions. Have time for anything else?
Any other question?
I would have one. It may be a huge one, so feel free to answer it in a short
I
way.
love.
So
I'll try.
Okay. So we've reached a point where we have opened a second company. So we have a consulting business, and then we have kind of the tech startup, which is an app. And for a variety of reasons, having nothing to do with human resources, we need to have two companies.
Mm-hmm.
But it's also an opportunity to do some of these transitions in a way that might be less fraught than having people feel that some people are becoming employees and some people are not. Do you see what I'm saying? So, and this, even just this session today has been very helpful for me in terms of how to think about it. But would you have any general guidance about that?
Yes, thank you. Congratulations. That's great business success for you. You can never go wrong by hiring people as employees. So if it suits you and everybody to, regardless of could they be a contractor, if it suits you all to make them employees, go for it. That builds it builds more loyalty and stability and goodwill. If you can't do that, I think the best thing to do is when you have an all company meeting, explain, this is weird legal stuff, there's laws I've been advised, but you're all our family. You're all our workers, you're all a big part of our organization, and let's not worry about designations. Does that help? You can say no.
It helps. I guess my question was really kind of, let's imagine I have a bunch of people that are contractors or interns right now. None of them are employees. I still don't have money to make, and we can go back to that conversation, but it's still not possible to make everybody an employee, just not possible.
Yep.
It is the right time to start thinking about who can become an employee and how to untangle that. Like, in other words, I like what you said, like separating out some of the legal issues from the who's the best consultant or who's the more senior. You see what I mean? Not making something where that's a reward, but rather it's around the transition, right? It's around the mission. It's around roles.
Yep.
I don't know.
I love the I've been advised by an expert that it's time, based on the stuff from the Department of Labor, it's time to classify some of you differently. And then do your best to make sure that the people who wound up in a bucket of employees don't get these gorgeous, wonderful benefits that they get to parade around in front of the other people. Then it's impersonal. If it was just some attorney, thank you. Just some attorney who told you. Florence?
Thank you so much, Danielle. Well, I have
Thank
some more
you.
comments, but and questions, but I think I'm very conscious of everybody's time. We're coming to the end of the hour. So thank you so much, Danielle.
Thank you. And I'd love to take questions and comments even after this too.
Yeah, so we can continue the conversation afterwards on LinkedIn or on by email.
Right.
We're going to send this recording to all of you and to the people who were registered, and we will put some links to the to the documents and the advice that Danielle talked about. Jack also mentioned certain things. He and I are going to talk about maybe some tools that we can share with you for assessment, in particular the assessments we'd recommend, and I'll also share some websites where you can organize your where you can advertise your positions beyond the usual suspects.
Great.
And if you have any questions, I think, and we'll send you a quick survey to ask you, how this was for you. So yeah, any burning question before we close?
Great. Thank you all. I'd love to be of any help to you all, and please just email me. And I love talking about and talking through this stuff. Thank you, Florence.
Thank you.
Hey, Danielle, is your email in the invite, or is it available?
We're going to share it to everybody in the follow-up.
Okay.
Make sure
Thank
we share our
you.
LinkedIn and everything.
Thank
Okay.
you very much. Yeah, hope to see you
Thank
all
you
on
very
LinkedIn. Thank
Thanks
you.
so much.
Thank you.
Appreciate it.
Bye.
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 Thank you.
Bye, Jack. Thank you so much. How
Bye.
did you hear? How did you hear about this? Because we've
Yeah, I mean, I just started my own consulting practice, and
hold on. I'm gonna stop the recording.
Sure.
I'm working against the